Hi, in this video I'm going to talk to you about complicity. Now, complicity is something that we discuss obviously in a lot of detail in chapter 12 of the textbook, but in this video, rather than going into the intricacies of the offence, rather I want to help you with a structure for how you should go about analysing or how you can go about analysing and applying complicity within particularly a problem-based answer. Now, to start off with, it's worth acknowledging that complicity is a particularly complicated topic, and it's relatively inevitable that it is complicated. So if you think about it, in a way, complicity is something like the inchoate offences, and particularly the inchoate offence of assisting and encouraging. So we have to look at what the defendant themselves is doing in terms of assisting or encouraging another party to commit an offence. Or to use the language of complicity itself, aiding, abetting, counselling or procuring that principal offence. Now, that involves looking, of course, at the Actus Reus, the physical conduct of our defendant. But equally, it's important to look at the mens rea of our defendant, both in relation to what they're doing in terms of their knowledge or intention, whatever, in terms of their own behaviour, but also in relation to the defendant's mens rea as to the principal offender, the person committing that principal offence that's aided or abetted, both in terms of their mens rea as to the conduct of the principal offender and their mens rea as to the mens rea of that principal offender as to the state of mind that the principal offender will be acting in. Now, that's all broadly equivalent to inchoate liability, but then of course for complicity we have this added dimension that principal offence that's aided or abetted, counselled or procured must have actually come about. And so now we have a principal offence in the real world, and we have to compare what happened in terms of that principal offence to what the mens rea of what the expectations were of our defendant at the point of the assisting or encouraging. So in that way, inevitably, complicity involves a multitude of different stages and different points of analysis. And so the most important things for you to think about is to identify a route through that analysis in order to compartmentalise those issues and make your analysis as straightforward as possible. So where do we begin? And the first point we begin with, I would advise certainly for complicity, is actually not with the actions of the defendant, but rather the actions of the principal offender. And we have to ask, was there a principal offence? Do we have something to base around potentially a complicity case? Having identified the principal offence, the second stage is then to look at what the defendant's role was in relation to that principal offence. Now, this is important. We spend quite a lot of time on it at the beginning of chapter 12, because just because there's multiple parties doesn't mean that we're necessarily dealing with complicity. So it could be that our defendant simply commits that principal offence as a principal offender, in which case complicity is irrelevant. The defendant has the actus reus and the mens rea. Or it could be the defendant and another party both commit that principal offence together as co-principals. Again, if the defendant has the actus reus and mens rea, then there's no need to look for complicity. Thirdly, it could be that our defendant completes the principal offence as a principal offender through another party. Now, if that party is an innocent agent, if that party that you're completing the offence through is entirely unaware and his behaviour is not criminal, then we still say that the defendant is a principal offender, even though they're doing the action through another party. A nice easy example of this would be, for example, I want to kill a particular victim, and so I give another party a poisoned apple and say, will you please give this apple, not poisoned apple, will you please give this apple to Lucy? My friend gives the apple to Lucy, Lucy eats it and dies. Now, in that scenario, as long as the go-between person had no idea that the apple was poisoned, then they've done nothing wrong. They've simply supplied an apple. And in that sense, they're an innocent agent. And their behaviour, their choice to pass the apple, although essential for my criminal venture, was not something that was done in an informed way, and therefore doesn't break the chain of causation between my actions and the death of Lucy. And so therefore we can still say that I'm the principal offender via the doctrine of innocent agency. Now, it's only in the final stage where accomplice liability becomes relevant, and that's where I aid, abet, counsel and procure, i.e. I assist or encourage or I cause in some way another party to commit an offence. And that other party, that principal offender, must actually commit an offence. So they are not an innocent agency, they're not an innocent agent even, but rather they're a criminal agent. They are someone who has committed an offence as the principal offender, and my liability derives from theirs, from my actions of aiding or abetting. Now, in terms of that, having identified the role and the fact that potentially complicity is relevant, we then need to apply the actus reus and mens rea of the offence in the standard way. So first of all, in terms of actus reus, we're looking for something from the defendant which is aided, abetted, counselled or procured. Now, aiding, abetting and counselling essentially just transfers as assisting or encouraging, and procuring is when you cause an element of the offence to come about. So an obvious example would be something like, if I spike the drink of somebody with alcohol, they then commit an offence of drink driving, then I have caused that element, the fact that they're over the prescribed alcohol limit, I've caused that to come about. It would be odd to say that I've assisted or encouraged their drink driving, rather I've caused it to come about, so therefore it would be procuring rather than aiding, abetting or counselling. So first of all, in terms of the actus reus, we need to identify behaviour of that kind. Then in terms of the mens rea, there's essentially two levels to the mens rea for complicity. What we might call an inward-looking mens rea and then an outward-looking mens rea. So first of all, in terms of the inward-looking mens rea, I must have acted, aided, abetted, counselled, procured, with the intention to do so. Then in terms of the outward-looking mens rea, outward in the sense that I'm looking at what the principal offender's doing, I must, for complicity liability, at least foresee a risk, I must be reckless as to that principal offence coming about. If both of those two are satisfied, then this part of the mens rea of complicity will also be satisfied. And then finally, the final stage within our analysis is to then look at factually what happened in relation to that principal offence and compare it back to what I anticipated might happen within my mens rea as a defendant. Now, when we look at that, there is a whole host of rather complicated rules. Now, within the textbook, and now as I discuss with you, we've chosen to break that down into 4 potential scenarios, so you can start to compartmentalise the types of cases and the types of issues that you need to discuss when you're applying problem facts. The first one is the most straightforward. This is where the defendant foresees a particular offence coming about and the principal offender completes that offence as it was foreseen. In this scenario, the factual comparison between what actually happened and the mens rea of the defendant is good, and so therefore we have liability for complicity. The next scenario, though, is where actually the defendant foresees something, but the defendant foresees a less serious offence than the one the principal offender actually did. So, for example, the defendant, I might foresee the principal offender beating someone up, but in fact they killed them. Now, in that scenario, we have to think about the rules that apply there. If the defendant foresaw less than actually happened, what liability can there be for complicity? The next scenario, the third one, is where the defendant foresees something more serious and the principal offender does something less serious. So this time I might foresee a murder, but actually what happens is simply an offence against the person. And again, there's a set of rules that are applicable there. And then the final potential, the fourth one, is where the defendant foresees a particular offence happening. That offence, broadly speaking, does happen, but in circumstances which are fundamentally different from that foreseen by the defendant. So, for example, I might foresee the chance that the principal offender might kill the victim when beating them up with their fists, but actually what happened was the principal offender killed the victim by shooting them. The circumstances there, the outcome is the same, the victim dies, but the circumstances that brought about the killing are very, very different. So again, we have to question to what extent my liability as an accomplice can derive from what has actually happened because of those differences. Okay, so it's that step-by-step analysis we need. The rules here are always going to be relatively complicated, but actually when they're broken down in that way, when you look at what is the principal offence, what's the role of the defendant in the principal offence, what's the defendant's actus reus, did they do it, what's the defendant's mens rea, did they have it, and finally, what is the comparison between the mens rea of the defendant and what actually happened in relation to the principal offence. If you break it into those kind of elements and you analyse one at a time, it can become much more manageable in terms of, and clear in terms of your analysis. Thank you.